Okay, hello everybody, and welcome to another episode of BHBA Family Law Presents Direct Examination with Dan and Lauren. Along with Lauren Youngman from Youngman Reitshtein, I'm Dan Bemel, financial advisor and certified divorce financial analyst. During each episode of our show, we explore our guest's personal and professional history and dig into a meaningful legal topic. Our upcoming guests, always the first Wednesday of the month at 12:30, will be Judge Lawrence Riff in July and Dana Lowy and Doreen Olson in August. The fall schedule will be announced shortly, and the sign-up links for those two episodes are available in the chat box and on the bar calendar. Lauren.
Thank you, Dan. Good afternoon, everybody. You'll receive your MCLE certificate shortly after the program. Please make sure to take a moment and complete the survey that's included with your certificate. Program materials were emailed to you about an hour ago, and you can find a link to the materials in the chat box as well. The family law section is sponsored by SoberLink, White, Zuckerman, Warsofsky, Luna, and Hunt, and Our Family Wizard. SoberLink. SoberLink system combines a portable breathalyzer with wireless technology. Trusted for use in child custody cases since 2011, SoberLink is the only system that combines court admissibility in all 50 states and Canada, facial recognition and tamper detection, real-time results, and easy-to-read advanced reporting. Trust the experts in remote alcohol monitoring technology for your custody cases involving alcohol. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. Thank you to our sponsors, and now let's begin the program.
Okay, let's get to it. Today, we're talking with Kiley, partner at Elkins Kalt. The breadth of Anne's career is really just amazing, and really her commitment to educating both the current and future generation of family law practitioners really stands out, and that's one of the main reasons why we asked her to join us. As a professor at USC and as a lecturer for the Rudder Group's California Family Law Report, it's hard to think of many attorneys with a better grasp of the law and of complex issues within the law than Anne. So Anne, first, thank you so much for being with us.
Well, thanks for having me. And I like the snappy Beverly Hills Bar intro. It's very nice.
The best. So let's go back. I think when we've been talking to people on the show and around the bar, I think one of the things that is always a great place, one of the places that's always great to start is that decision, that run up to law school. What led you there? Coming out of college, what brought you into this career path? Let's start there.
It was so long ago. It's a different time. Honestly, it was the 80s. And I think you just did it. You got out of school and went to law school. I liked school. I mean, I didn't necessarily like being in Michigan, but when I got into Michigan Law School, there was no question. And I think I had a very strong mother who was quite opinionated as to who women should be and what I should be. And I think she had wanted to go to law school. She never even went to college because she had 5 younger brothers, and her parents said, you're going to work at 18 to help support your brothers. So my guess is my entire, environmental circumstances led to me being in law school. Plus my dad was in law enforcement. So it was just around.
And when you went to law school, what was that experience like? If you remember.
I do. I don't mean to sound arrogant, but it really was natural to me. And I think I took it what I'm mad about is how my last semester, third year, I really blew off. So I didn't get my magna. It sounds silly, but I think I was a very immature. I was young too. I had a July birthday, 22, 23, 24-year-old when I graduated. I was highly immature. So I had a lot of fun in law school. But I liked a lot of the coursework. I liked school.
And then you ended up coming out to LA as a summer associate, right?
I went to Chicago after first year and LA after second year.
So what was that experience like? If school wasn't challenging, or if you weren't as in the game as much as you maybe think about now, what was the summer experience like as an introduction to practicing?
Well, it's not that school wasn't challenging. I just liked it. The summer experience was even better than school. Because again, it's very difficult for people who've gone through school in the last 10, 15 years, 20 years, maybe even, to understand what was going on in the 80s in these summer associate programs. It was just one party. You did no work. And I mean, that was my experience and the experience of my friends. We were these huge summer classes of, I don't know, 30, 40 people, and they'd all say the same thing. So I was at O'Melveny and I knew the Gibson and the Skadden and the Paul White, and we all just hung out and did things pretty much. I don't think anyone did very much work at all, either in Chicago the year before or LA, certainly. Wasn't my experience. And none of my friends in New York did any work either. So you weren't, it's not like you were trained in the summer to know what, what practicing law was like, or B, really what the firm you were going to work in was like, other than they were wonderful and sent you to Lakers games and operas and whatever you wanted, you got.
Okay, so then how did you end up coming out to LA from that experience in Chicago? What made you leave? It sounds
I was an LA summer associate. I grew up in the Midwest. I needed to get out of, I grew up in Grand Rapids. It felt like a small confined town, and I wanted to be in New York or LA. Without really thinking it through, I needed out of the Midwest, which now I really like, by the way. I think having a big white house with black shutters would be lovely, but those choices weren't made.
Well, it sounds like if it was a party experience, that's a pretty good running start to the LA lifestyle.
Oh yeah. Well, LA was a lot more open than New York. So when I was interviewing in New York and seeing what New York was like, it was just tall buildings and it was dark. And then you came out to LA and it was open and you had the ocean.
So take us through those early years, like the initial practice. You started O'Melveny, the rude awakening, right? From the difference between the summer associate program and actually practicing. What were those? Tell us a little bit about those early years and what it was like at O'Melveny, at a big firm in the 1980s.
Well, I started at O'Melveny in 1989, and I had decided I want to do corporate for no reason other than someone said, hey, transactional work's great. I mean, honestly, it's not like I was guided or put the thought into the future and what I was good at and what I wanted to do, which is what I find so important, particularly when I do teach at USC, to say, and I think people are really different now, especially when you're getting these huge loans out of law school. Really, who are you and what do you want to do and what is available to you in law? That to me, rather than being miserable, is very important. But I didn't do any of that. So I started out in corporate. It was right when the M&A crashed. I think Jim I came in on like one of the Muppet mergers or something like that. And he had the flesh-eating bacteria. So everything was in an array. And I just remember I think I was going to go back home for Thanksgiving or something. I still had that school mentality. Hey, it's Thanksgiving, I'm going home. And no, you're going to stay and work. And that was probably my rude awakening. And there was it didn't matter that you got in early, but you were going to stay really late. And I know family law lawyers work very hard. I do. The people I have cases against do. People in my office do. So many of us do. But the kind of that big firm 2,500 hour a year requirement is deadly. And I saw that and I didn't want it, which is why I was looking for something else to do. I don't think I would have done very well there.
And how did you transition over to family law then during that time when you started thinking about maybe I need to be doing something else?
family law had been something that I didn't do any litigation in law school, so I really had no idea what litigation was. I'd taken a family law case or class, but it was basically constitutional law taught by the property professor with whom I really got along. So he gave me this high grade in property and family law. And I thought family law was very interesting because at that time we were talking about constitutional issues like gay marriage. And remember, this is 1989. And you saw where it was, you saw what the argument was. So it was a very exciting class, and touching on surrogacy had nothing to do with, while family law is not pots and pans, I mean, nobody was talking about people who were going to be arguing over their dishes. So it was this high constitutional case, and I found it very interesting, as well as the personal aspect and what people were going through. In any event, it was kind of the back of my mind. And there was a woman, her name was Penny St. John, who was at O'Melveny, and she was in the banking department, and a deal came through, I think with Bankers Trust or something. And when I first came, I mean, Penny was stunning. So she was just this beautiful woman. And I thought, wow, here's this third year associate who's beautiful. She seems to have it all together. By the end of the summer, not to be mean, but she looked terrible. I don't think she'd slept for a couple of months. I mean, literally, this very beautiful woman who all of a sudden looked like she'd just been dragged on the back of a horse down Wilshire. I mean, really beat up. So when I came back, I said, hey, what happened to her? And they said, she's gone. So I asked one of the associates, where was she? And they said, oh, she went to this place called Trope and Trope. And I picked up the phone and called her. And she said, you really should think about what you're doing. One of the first people who'd ever said, where do you want this to go in law? Why don't you come talk to me? And I walked into Trope, and there she was looking great again. And I said, family law sounds good. That's honestly
the family law. I'm sure everybody watching will agree. Family law is the key to longevity and good looks. That's what you're saying.
Exactly. So yeah. I was like, well, and then, I mean, she introduced me to Sorrel, and Sorrel was a very captivating man. And if you were in Sorrel's eye, he would make you feel like the most special person in the world. And he would spin a tale of family law that nobody wouldn't want to do. So once I got in, there was no question.
So what was it like working for Sorrel?
It was very interesting in many ways. He certainly shaped who I am. And I hear his voice in my head very often. And when things go well, sometimes I say, hey, look what I did. He was a very, very important part in my life. His passing last year, as well as Steve Kolodny's. These are people who are so close to my heart. Not to say that Steve wasn't a fierce adversary. And the fun of the interaction between Steve and Sorrel and Manley and Dan and Dennis, all those, and I hope I'm not forgetting Bob Kaufman, Lance, all those people and how they were and interacted was fascinating. And I was fortunate enough to be kind of included in that so I could see it. And I learned from each and every one of them. There's a guy named Jerry Goldberg too. So I was in a very fortunate place in the first, 5 or 6 years where these incredible practitioners, I got to work on cases with Sorrel where incredible counsel were on the other side. And of course, remember, I mean, this is going to sound like I walked to school in the snow, which I did, by the way. When I joined Trope, we didn't have email. We didn't have computers in our desks. Sorrel was very anti-technology. My secretary, who probably is 120 at this point, did everything on her IBM typewriter, and she still used carbon paper. So you didn't have these reams of paper. I mean, probably the fax machine had just been gotten at Trope. I kid you not. We didn't have voicemail for years because Sorrel didn't believe in it. You had to call the receptionist, who's still around, one of them, and then you'd be put forward to a secretary and then ultimately get to an attorney, and people put up with this. So it was a very old-fashioned, I think, gentlemanly practice, and Sorrel was going to keep it that way. You had to pull him into everything else. And he never had a computer.
How would Sorrel have done with LaCor Connect?
He wouldn't have.
He just.
And you know what? I honestly think, I mean, even when he was mentally always wonderful, but toward the end, physically, he had his challenges. He would still go to court. He had a big thing about reading the court, and he was brilliant at it and looking at people's eyes. And he got away with murder with judges, but he would look at their eyes and say, I see your eyes. And where you can see people in court, you can sit there and see this all the time, where they've got their agenda or their script and they're going on and on and on, and a judge is doing something else or just keyed out. I was in court with Sorrel dozens of times. That wouldn't have happened. So he wouldn't have done LaCor Connect, I'm sure. I don't know how he would have managed through COVID, but being in the courtroom and your presence and how you were dressed and making sure that your shoes were shined were all very important things to him.
What was the family law community like when you first started practicing? You just listed a lot of legendary Los Angeles family law practitioners. Were there a lot of women practicing family law when you started?
Yeah, I mean, Judy Foreman was, of course, Pat Phillips. There were, so when I started O'Melveny, women were still in those little silk ties, and I didn't want to wear them. And there were women who were, very high up in O'Melveny, and I know that it was difficult for them to get there. And they didn't really, they didn't really want to see a change into, a more relaxed style of dress or shorter skirts or whatever it was that you were going to wear, not to be dressed in kind of a man's suit. I didn't feel any of that from the women in family law. I didn't feel like they felt like they were due something. There were, but when I think back, you're right, Lauren. When I think now, I think of women are primarily over half of family law, and most of the best litigators are women. It wasn't like that at that time. I think it took some time. There were plenty of good ones, but and Marianne LaGuardia was at my firm, and she was phenomenal. So yeah, there were a lot of women and good role models in that way.
And what reputation did family lawyers have in the legal community? Was it a different, and has that changed over time?
I don't know how much it has really. And I don't know that I'd been aware of it that much. So Trope and Trope dissolved in 2016, and I came over to Elkins, which is a bunch of guys left Jeffer Mangels and started Elkins about 11 years ago. And I had worked with them because either on corporate matters or real estate matters on cases that I had where I needed real estate, corporate, tax, estate planning, because the guys, I call them, who founded this firm are just incredible people and lawyers with ethics, integrity, great knowledge. So that's why I knew the firm. And when I came in, I really realized that all of these people had a complete misconception of family law as well. Like they said to me, it's not that we want family law, it's we want you, we like you. And I had to show them, particularly the litigators here. Well, one of them, and he's great, he's my partner. And he said to Katie, a lawyer I work with, wait, do you guys use the CCP? And he wasn't kidding. He had no idea. And I was like, Amit, it's what are you thinking? He's like, I thought you operated out of this family code thing. I was thinking, well, yeah, but surprisingly, the CCP and the evidence code, they work for us too. And you guys can help with our motions to compel. They don't want to. The litigators here run so far from family law. It's funny.
What's that been like? Something we were talking about before, we're curious about, like Trope and Trope, boutique, family law only. Now it's a department at a much bigger firm. How does that fit, right? Is there a difference? You can bring in other experts. How does that actually work day to day?
It's worked for me at least very well. And I'll say friend, but then it sounds like it's bad if he's opposing counsel, and he's opposing counsel all the time with Scott Weston, who's over at Fox Rothschild. And we talk about that a lot because he's in a similar situation, although he's more of a national firm. It works really well, but it works because of the structure of this firm and who the men are who founded the firm. It's a very sort of Roman Republic egalitarian a democratic firm. So everybody has their say in their votes and nobody's overseeing me. I haven't had a lot of conflicts. I thought that there would be. And sometimes, there'll be estate planning and they represent jointly. So that was the big thing. The different mentality between estate planners and family law lawyers, I've really learned a lot about being here. The whole idea of we jointly represent instead of separately representing, the way estate planners think. And there's a lot of synthesis between the two of us, but there's just a different train of thought. So I know I've become a better lawyer by being exposed to the way the estate planners are thinking.
Unpack that a little bit more. What do you think it is that makes them different, or the way they think?
Well, one, they're so tax driven. I mean, if you think about it, when all those cases came out and the estate planners were doing transmutations relatively thoughtlessly, just for the stepped up basis upon death, which makes sense, their entire life, I mean, they'll sit there and take all the assets away and give them to the kids because that's going to work estate. They just think, they think in the future. They think about this family wealth being around 200 years from now without thinking about, well, you just took all the assets and gave them to the kids and they're living on the income and now they're going to get a divorce. And how's that going to work? Or do we want to do it this way? Don't we want to think about this marriage could end? So they've helped me think about this marriage may not end, and more creative approaches, particularly in a family law dissolution, to the dissolution that may be able to save the wealth of the family. That to a large extent, when you think about economically what's happening, throughout the economy with divorce and what that costs, with the lawyers and accountants fees, certainly, but what it costs the family, it's a tremendous waste. I mean, more people should stay together and live in separate houses, and they'd be better off than going through that divorce. Obviously, there's personal happiness, but being kind of more focused in the estate planner mentality of what can we do for the benefit of this unit, notwithstanding that it's dissolving, has been helpful for me. And hopefully they've helped with my input about family law. And don't you realize everybody gets divorced, which is my mantra, which isn't true. But it certainly feels like it with what we do and how busy we all are.
You have a good chance of being right if you say that.
Yeah, exactly.
So similarly to how the estate planning attorneys have sort of influenced the way that you think about cases, does your civil practice background influence the way that you approach litigation that makes you take a different approach than a typical family lawyer with no civil litigation background?
But I don't really have civil litigation background. I mean, I've been doing family law since 1990. That's all I do. I've never done a jury trial. I think I'm fascinated by people who can do it. I think that's a wonderful skill set. But I think the skill set of family law lawyers is so unique. What it is that we do and sort of the fields through which that we're not educated, but we're really dealing with. I have so much respect for family law and family law practitioners. It's really hard. So while I think a jury trial, that's a great skill set, I think the skill set that we as family law lawyers have, everyone should be proud of.
Let's go into that skill set a little bit more. I think that's a great pivot point to talk about the way you actually run a case. I want to spend a couple minutes on that. So starting with intake, right? When you're interviewing a prospective client and they're interviewing you at the same time, it's a really interesting dynamic. What are you looking for to know? You said everybody's busy. You don't have to take everything that walks in the door at this point. So how do you manage that first interaction and what are you really looking for?
Sometimes it's what interests me. And sometimes it's, I had a call from this woman and I really kind of don't want to take anything for at least a couple of weeks. So maybe I could get a weekend off. But I just felt so bad for her. So I'm hoping, as I'm assuming everyone does, I don't want to take someone who can't pay me. I don't want to take someone that I'm relying on going into court and getting a fee order. I do want to help people. So there are times that I'm going to take something that's not going to be economically driven, but because I want to help. And sometimes there's just a connection with somebody. I can't deal with people who aren't going to disclose. people will say, there are people who say, well, are you going to do this, or I need to know creative approaches. And I say, I'm not your right lawyer. I mean, I have often said there's a line. I'm not even going to come close to the line. I'm going to be so far away from the line that if that's not the lawyer you want, don't have me. And it's no criticism for however anybody wants to approach it, but this is what I'm going to do. So I don't have interest in people who call saying, I'm thinking about getting divorced. What can I do and how can I do it? That's not the type of person, A, who should hire me, or B, who usually hires me. I don't want to have arguments about disclosure. You have to do it. I don't like to waste time. I don't like noise and creating issues. So if you have to do it, just do it and let's move on. I can't change the past facts. I can give you guidance so that the future facts won't be so bad. I mean, that's sort of my approach. I want to be direct. I don't, like Sorrel, we used to all kid on, he had Teflon. He could tell somebody, you're going to get $5,000 a month in spousal support, and they wind up getting no spousal support. And they gave him a hug. Thank you so much, Sorrel, for everything. That's never been me. If I lose, I hear about it. So I think from my standpoint, managing expectations is important. And I used to see the dynamic between Sorrel and Bruce Cooperman. If I told you the number of people who've gone through Trope, it's stunning. We should have an alumni association. There's so many. So Sorrel, you say, oh, Bruce, you're so negative, but Bruce was realistic. Bruce would, so I try to model myself after that, where Bruce would say, look, here's what the discretion of the court is. Here's where it could go. I will do my best for you, but you need to understand it could go this way or that way. So that's what I do. And if there are people that I don't think are going to listen to me or aren't going to be receptive to it, then it's not a good fit. Doesn't make them bad or me bad or either of us great. Rather, what you want to me in an attorney-client relationship is this open communication. This person has to trust you because you're dispensing a ton of advice. And if they're, for any reason they can't work with you, I mean, so many people will say, oh, should I have a man or a woman? It doesn't really matter except in your own mind. And I'm thrilled to refer to people that I have respect for, just as I'm fortunate enough that people refer to me because it's not a fit or they don't have time. So I've gotten my best cases from other lawyers, including other family law lawyers in LA.
One thing that you just said was the being honest and direct with your clients, but that's not always easy. So how do you, is it really a matter of just not sugarcoating anything, or is there some finesse in breaking the bad news or getting clients to understand that the mediator just isn't going to see it the way they see it, and they gotta have that mental reset? How do you actually do it and structure those conversations?
Well, I think you're right. There's finesse. If you've ever been to a doctor, you can see the difference. I mean, when I have twins.
Bedside manner, right?
Yeah, well, I have 22-year-old twins, and when I was pregnant with them, I shockingly found out I was pregnant, and the doctor was like, whoa, go see this specialist and let's see. And the guy's doing his ultrasound and says, oh, there's no heartbeat. They're probably dead. And I will never forget. I mean, and it was my birthday too. It was my birthday. I went in for a regular appointment saying, I don't feel well. And my doctor said, oh my God, you're pregnant. So go down to see this specialist because I think you've got twins. And yeah, no heartbeats, are probably dead. So I think of that all the time. That's not the way to approach a client. And had the guy said it, and by the way, they weren't, and they were born. So, but I lived in 2 weeks of misery. So you're right. There's a way that you need to approach people, and don't be like that doctor. That's what I try to think of.
What about the other side when you're in the position where the client wants you to be the therapist? How do you deal with that? You can't. No time for that. No, just saying that I'm $800 an hour. Why are you paying me to be your therapist? I mean, it's really, and I think I know I do, have to watch it, because I mean, I've gotten into habits of borderline, oh, narcissist, spectrum, all of that, maybe a combination. I don't know what I'm talking about. Type 1 business
stuff. Yeah, sociopath. Yeah. You have no business labeling people. And it's not, personally, I'm delighted if my client has a good therapist. I think it's really important for them. And there is there is a human element to our practice, obviously, and being a human being and showing empathy is very important, but that doesn't mean that I can help them with their underlying psychological conditions. I mean, I get it. I understand. To me, divorce is like any grief or whatever they say, the spectrum, if someone suddenly dies, it's the death of your marriage, however you want to put it. So understanding that someone's going through stages in a process and that I'm not a therapist, but I can be a human being. And I've gone through my own divorce. I did things that I never judge people. That was one of the best pieces of advice I ever got from a woman lawyer, by the way, in New York. When I said, oh, he married her. And she said, don't you ever say that. Don't you ever judge someone. So I'm not judging them. I'm just understanding they need help. And my job is to give them legal help. And I think that's appreciated.
And what about with opposing counsel? What's your approach to opposing counsel in general, and how do you address difficulties from the other side?
I try never to send those vituperative letters. And that's another client that I just don't hire me. If you're looking for me to send letters, as we all know, to the opposing counsel, your client is a sociopath, second coming of Hitler. That I'm never going to do it. It's a waste of time. I have zero interest in doing it. I mean, less than zero interest. And when I get those letters, I don't even read them. I can skim them and I'll send one line. I'm not going to respond. I just want to focus on the issues. And I'm lucky enough that for the most part, the opposing counsel that I deal with will do in kind. And yes, some of them send those nasty letters, but I just talk to my client and say, it doesn't matter. And if you really, I have a client recently who's just like, they're trashing me. Well, okay. But I mean, we're not in second grade. So I'm not going to respond accordingly. I'm not saying I'm perfect. I'm sure I do at times, but it honestly doesn't even raise my blood pressure anymore. I just think that's who you are, and that's how you decide to practice, or that's what your client wants. It doesn't mean that I need to engage. I don't want to.
Well, on another note, a question that we can't help but ask pretty much every guest that we've had on so far: how has your practice evolved and changed with the COVID crisis and the pandemic and remote practice?
If anything, I think it feeds off of my desire not to leave my office. So I think it's lovely. I remember right after it happened, and this woman called me and she's kind of crying and upset. And she hired me over the phone. I was like, this is wild. I've never been hired over the phone. I mean, remember, all the clients come in and you get the interview and, oh, I'm talking to this person, and this person. What about you? Which is all fine. But this woman hires me over the phone, and Adam Lipsick was on the other side, and we got it done, and it was great. The first time I saw her was on a Zoom in mediation. I think that's the only time I saw her. And the whole case got wrapped up beautifully. That was excellent. I mean, it was like, this is the best. Depositions, I find it great that you can be in Uggs and jeans. It's a little bit of a hassle with the exhibits, but you get used to it. I think I've had 3 long trials on Zoom, and it worked. So I'm not saying that's the way it should be. I am saying that there's a level of efficiency. Certainly doing court call to get a continuance is great. I don't think it's going to stay this way. I think most people are going to want to mediate in person again, even though I personally love Zoom mediation. And I found it very effective. I think that we're going to ease back into a lot more in-person contact. And I think most people listening would agree. We think it's important to be in court. It's going to make a difference to be in court. I don't think that's something you're just going to voluntarily not do.
What was the bigger pivot point? You mentioned back in the trope and trope days, getting computers, right?
Yeah.
Was that what was the bigger sea change for you in the speed? I mean, to a lot of people we talk to, the speed of this transition, the forced transition over the last year is what stands out. But overall, in terms of the practice, what do you think is going to be more meaningful long term?
I mean, because of COVID?
Yeah, like the nature of how the practice has had to change during COVID.
I think it was getting there. It just got there faster. I think that the 24-hour responsiveness to email and the people writing essays on emails and the expectation of clients that you're going to get back to them in a minute is more societal than COVID. It's the absolute lack of not having everything instantly, as well as nobody hears no anymore. So that to me is the bigger impact and challenge for everyone practicing law. Necessarily not COVID. It was coming anyway. And so all of a sudden people are far more accepting of electronic service. And now we've got the electronic filing. So yes, I do agree that things are faster. I think it would have happened anyway.
One of the things we also touched on was how you deal with difficult opposing counsel. And we've talked to some of our other guests about that, and just a breakdown. One of the things Laura was really stressing was her sense of an overall breakdown of collegiality as a problem plaguing the family bar specifically. But I know you kind of take a different view of the root cause. And I want to talk a little bit about the lack of familiarity with the actual law and rules of court. So let's talk about that from a big picture standpoint and then get into a few examples. I know this was some of the materials that we circulated. Has this been a problem in family law since you first started practicing, or is it something that is really becoming more prevalent now?
I don't think it's changed. I mean, again, going back to, I had Bruce Cooperman at Trope and Trope, and he was the walking Bible of family law. And remember, so the family code comes in, and don't mess me up, I think it's 1992. So our codes were dispersed throughout the civil code. It was a mess. And God bless the legislature. I mean, they did a great job trying to put together a cohesive code. And then all these things get into it. So it's kind of slapped and all over the place. And especially if you go through the DVPA and find out where you may have something in the 6,000 and then have to go back to 200. So you're all over the place. But in 1992, then all those civil codes like 4800.2 becomes 2640, I think. And 4800.1 becomes the presumption with 2542 or something like that. So all those things happened. And I remember Bruce with his little chart just memorizing it. And it was because that's who he was. And he knew the cases, or Ken Black, who had his photographic memory, and he knew the cases and it mattered. So I saw, myself included, you're busy with your job, you're busy with your family, those twins were born. So you can't do everything. And I think my biggest realization came when my youngest is like the biggest, boy's boy of sports from the minute he could walk. So he started club soccer at like 7. And I don't know if you have kids, but if you've ever been to these kids sports and those parents on the sidelines screaming, wheels, yelling at these little boys. And this one guy offsides. And I thought this man was going to have a heart attack. So I go back to my, I'm home, and I don't know I really don't know sports. I love watching my kids play and perform, but I don't care about the rest of it. So I said to my 7-year-old, what is this offsides? And he looked at me like, wow, I thought my mom was smart. It was one of those first things from my kids that, wow, I have a stupid mom. So he had these little football players, and he sat up and he puts them in a soccer configuration, but he's very disturbed by it. And he needs to let me know that it's not right to put football players in a soccer configuration. And I mean, this is my 7-year. And then he shows me what offsides is, and he moves it. And I'm sitting there looking at my 7-year-old thinking, this kid really knows what he's talking about. I mean, this is a kid who couldn't read, 4 years ago, and can't multiply, but I can, it was, but he knows, and he knows these rules. And then I asked him to show me football, and he had this high understanding just from his love and watching sports. And I thought about it. Here's a 7-year-old who knows the rules. And by the way, his now understanding of what is lacrosse, golf, whatever it is, he knows the rules. And I have found at least people who love sports really know these rules, arcane, crazy rules in golf about where you move that stupid ball, but you don't know the rules of your profession. And if this is what you're going to do, why don't you know those rules? Steve Kolodny used to say, read the evidence code once a year. I'd probably guess a large percentage of the people practicing family law have never read the evidence code. And it's not fun. It's not fun to read the evidence code. It's certainly not fun to read the California Rules of Court. Horrific to read the CCP. And there's some fun in the family code, but not really. The fun we have is cases, because there's a huge, in my opinion, schadenfreude in these cases. You read these facts and there's this horror, your heart can go out. There's this case McKeon from a couple of years ago where a woman's driving and gets into this horrible accident, and one of the children dies and the other child is severely brain damaged and disabled for the rest of her life. And then she has another child. Of course, they get divorced, and there's just litigation for years. It's a heartbreaking case when you read it, and you learn the law by reading that case. One thing is, I didn't know this before I read the case. There's actually a presumption that siblings shouldn't be separated, and it's cited right there in McKeon. So you learn it, but you learn it with this fabric of a Dickens novel. So that's interesting. And however, it's just a case. It's a case with facts, with an application of law. And particularly as you start reading, and this is the benefit I've had, at least from Rudder Group, I learned so much. When you start reading cases without trying to fit them into what you want them to say, you see what the justices are doing, and particularly the Supreme Court. They and a lot of the appellate panels are really, really honing in on statutes. I mean, read Brace, that you get a dissertation on how community property evolved, a little bit like Valley, and then it's going down technically on statutes and so many other things too. So if you know the statute, you're way, way ahead of whatever you're doing. And I think people forget that. We have a lot of new judges, they don't know it. We have a candor to the tribunal, and particularly those who've been practicing family law for a long time. In a very polite way, you can say, this is what it is. And I think a judge appreciates that.
In your experience, what sort of rules do you find, or, just the black letter law that other attorneys aren't really paying attention to or aren't showing proficiency in?
Well, I wouldn't say it's proficiency. I think everyone pays lip service. Not everyone. Close to everyone pays lip service to 5.98. And that's a mistake. That's your meet and confer. And so what good is it going to do you? You're going to go to court and they're going to force you to meet and confer in the hall. Do it. And exchange the documents. When you don't exchange documents as you're required, you're just setting yourself up. So the orders after hearing, we all get kind of sloppy and lazy on. And if you have someone who's abiding by the rules and you're not following that time limit, you're going to be out of luck. So you may as well do it. I'm definitely guilty of this one, not filing the preliminary declaration of or not serving the preliminary declaration of disclosure in the 60 days. You know what? You should do it. It helps move the case along. There's a reason it's there. And every once in a while, you're going to have a counsel who says, no, I'm sorry, get it done. And it helps get it done and realize preliminary declarations of disclosure, you don't need to make a claim about character. It's not required. You can read the statute and see that. So if you're so worried about putting a schedule of assets and debts where you have your client sign under penalty of perjury that something's community and it turns out to be separate, you don't have to do it. All it really is a balance sheet. This is everything I know. Whatever the character is, this is what I know. So those are the kind of things. It depends. There's strategic reasons to do everything, but that's kind of a slide. And the other thing, I think everybody knows the Business and Professions Code and everybody knows the rules of professional conduct. How they're following them is a different issue.
Do you that's something I want to talk about. Do you see, you talked about the gaps in knowledge with the bench officers and the bar's responsibility to help kind of coach them along, but are the bench officers themselves doing enough to enforce the rules and to follow the law?
Oh, I think so. I think you get these civil judges and they know the CCP better than any of us. And oh yeah, no, I really do think so. I think it depends, various, I'm always surprised when a judge lets someone argue outside the evidence. I mean, sometimes I guess they're just letting it in and they're going to rule against him anyway, or overruling objections and whatever they're doing, and they're going to let it all in anyway, or do what it is. But I just think it's wrong to argue outside evidence or argue facts that aren't, even if they're right, if they're not in the record, you shouldn't be arguing them, and you shouldn't be making representations to the court. You're not there to testify. That drives me crazy. And some judges stop it, some judges don't.
What else drives you crazy? I want to get like, what else? What are the other? I love that. What's the?
That's number one.
Is that number one?
By the way, yeah. And recently in the last, I don't know, 3 months, I was strenuously saying, well, how'd you find that finding? And this is it. And my opposing counsel, who's lovely, she was so gracious about it. She said, you know what? Here's where it is. And I apologized. I said, I am so sorry for wasting everybody's time. You're right, I'm wrong. And that's the right thing to do. I was wrong. So admit it and move on. It was my own pleadings. And she saw something that I hadn't. So to me, this is a profession that is your job. And if you don't know the facts of your case, either know them or know what's in the record, or have someone else argue it who does know the facts. Don't just make things up. Nor do I think it's right to be just making negative, disparaging statements about the opposing party. It doesn't help. And this is a family, and if they have kids, they're going to move on. I mean, what point is there? Those are the things that I wish. I mean, we're not in London where my esteemed colleague, with this big, long, flowery graciousness. But sometimes I think that would be nice.
Yeah, maybe we would benefit.
Yeah,
Yeah.
I would like
the wig would look lovely.
Yeah, that would do good for me. Yeah.
Well, okay. And so with our last few minutes, we also wanted to make sure to touch upon the fact that you're involved in teaching, and that maybe you can help instill these approaches in future generations of lawyers, as well as practitioners that benefit from your work with the Rudder Group. When did you decide to get into teaching and to become a professor? How did that come about?
Oh, I was lucky. Well, Sorrel was a big donor at USC, and they had a domestic violence clinic, and I think they had someone there. I don't remember what happened to her. Something bad happened to the woman who was running it, and all of a sudden she was gone. And by the way, I knew nothing about domestic violence at this time, and there was no DVPA. And Sorrel said, "Hey, Ann, go run the USC clinic." So it was almost like, in my mind, like being a DA and appointed the first day and given a file and said, go into court. So that was fascinating to me. By the way, the USC clinic is now very different, but at that time, that's where it was. And they just needed this Band-Aid. And then I was lucky again, and very much Sorrel driven, to be asked to teach family law. And I learned so much. And I'll tell you, you don't even have to you can do it selfishly. If what I have learned from Tom Lewis teaching Rudder is incredible to me. It's kind of frightening, actually, when I think, oh my God, I actually know that. And his thought process and why it is he's reading cases with how's the appellate court going to review this, and what that does to enhance my own thought when I'm going to walk into an evidentiary hearing, just having listened to him so much. So do it for yourself, because you're going to be a better lawyer, and do it for others, because if you're interested. You may not be interested, but if you are, I think it's a great thing to do. I'd rather do that than practice law.
Is there
I think
different?
Oh,
No,
I
go
think
ahead.
Barrett Daly has the perfect life. I really do. I would love to do that.
Is there a difference when you're teaching law students versus teaching with Rudder, practicing attorneys, basically?
Absolutely. First of all, the law students are scary. One of the first classes at USC I taught, and this guy comes up to me, well, who has the burden of proof? I don't know. I don't think about burdens of proof. Now, Tom Lewis will shoot me for that, because burdens are but I was like, I haven't even thought about that. This is not what we're dealing with here. We're trying to figure out how we're going to divide this property, or what is it? And also it really made me think about what community property is, because all these students are coming in taking property. They don't understand that community property is basically partnership law. And I never thought about it that way. Growing up, Michigan's not a community property state. It just is what we do. We've got a code and we go on, day by day. And when you're in front of a bunch of really smart people, which is what the students at USC are, super hard to get into, and they start kind of questioning you because they've got questions you wouldn't think of, coming at it from a different way. So you start to think about what you do differently. And that's my whole, community property is a partnership, and the operating agreement is a bunch of codes and case law that nobody knows when they get married. That's now what I think of our system. And would you ever make an investment in a firm with, or a real estate investment without having an operating agreement? So it helped me think that way. And they're very smart. It's a fun thing to do. It's exhausting, but it's fun. I won't do it next fall.
Oh, are you able to mentor any of your students?
Yeah, I've hired a lot of them. And one of my students from community property this last semester is going to join us, like the first person right out of law school that Elkins hired. So I'm proud to be doing that, because that's the model that I came off of, where you were hired by a big firm. And I two of the partners of Kolodny are over here now, Harley Gassmer and Marina, and we all sat down and said, listen, let's get someone really smart out of law school and just put the time into training them. So instead of complaining about people, and I think there are so many people in law school who are interested in family law. And as practitioners, everyone's running around trying to find someone who's been practicing for 3 or 4 years. But why not put the time into training someone? Hopefully it's going to work out well. I think it will.
I'm sure your summer associate program was just like the one you went through as well.
We don't have one. We don't have one. But this particular person, Gabriel, he's got tech skills beyond belief, and he's really smart. And I know he's going to be a great lawyer. And I think it's exciting to train someone the way you want your associate and hopefully partner someday to be.
How do you guide the students who aren't sure what they want to do? The students that were more like the way you described yourself going through. Is there a difference versus the ones that are so focused on family law now?
Oh, most of them are. Nobody's taking community property. They laugh at family law. And those taking family law sometimes just want a credit, or they went through their own parents' divorce and they want to see what happened. Very interested in custody. They have all had some experience, and they kind of want to understand it. I mean, even the basics. It doesn't matter where you get married. It matters where you get divorced. I mean, people don't know that. People call you all the time getting divorced. They have no idea. So that kind of thing, I don't think most of them do want to. I do like talking. I do like people thinking about where they want to go and trying to say, hey, this was my experience, and this is what worked for me and didn't, and what interests you. I wish my 22-year-old daughter who's headed to law school, I wish she would do this. Just go take a personality test, find out things that you're going to be interested in. Most of my female friends from law school aren't working anymore. They gave up when they had kids. They had no interest in it. And that's sad. I mean, these were very well-educated, smart women. I don't think that's necessarily true of the generation that's coming through now, but it certainly was in mine. So finding something that you're happy doing, whatever effort it takes to figure that one out, I think it's important. That's what I do with the students.
Speaking of the next generation of attorneys and family law attorneys, what are you most excited about the new generation, like thinking about your current associate and your students?
Oh, their tech skills. It's extraordinary. I mean, anyone who has little kids can see that their 5-year-old can do things that they can't. And they're so much smarter about social, like these people in their 40s, what they're posting on Facebook. You don't find 22-year-olds doing that. They are far more aware of their reputation and what they're putting out there on Instagram and Facebook than older people are. I've found, at least. They're not doing dumb things. So that's what I think. I think they'll be far more tech savvy and far more social media savvy than a lot of us were or are, I think.
Is that going to lead to better practitioners, do you think?
I hope so. I think technology, the things that can be done right now is amazing. I think it'll lead to a lot more efficiency, but ultimately the better practitioner is the one who knows the law of the area that they're practicing in, takes the time to do it. You know, I'm sure everyone listening's got the same thing. You're working 12 hours and you can bill 7 or 8 of them. It's just the way it is. You know, spend your weekends reading cases, not because it's fun, but because it's what you do. It's your profession. I guess there's such a difference between job and profession, and thinking of this as a profession and a privilege. It's how I feel. I feel very, very fortunate to be allowed to practice law.
What's the flip side of that? Is there anything that makes you nervous and I'm thinking more about the family law bar specifically, if all those opportunities are exciting and this next generation coming up is exciting to you, what makes you nervous? Is there anything that makes you nervous about the state of the bar or the future for the family law bar?
Not really.
Well, that's good.
I know, not really.
Yeah.
I think that there's I mean, look, you had the Bill Gates divorce all over the place. There's a much larger recognition that these are huge transactions. I mean, what some of the civil cases here pale in comparison to the amount of money at stake in the cases that we're dealing with on the family law side. So they're arguing and fighting over $900,000, and I'm arguing in dealing with $600 million and a $30 million swing on an asset. So these are big, complicated cases. And I think that the LA bar has done a really good, family law lawyers has done a really good job of bringing that into a higher awareness. I think we have an excellent level of practice. And it's not just LA. People down in Orange County, there are great lawyers in Orange County, great lawyers in San Diego, San Francisco, all throughout California. You have such high quality lawyers. And I don't necessarily think bringing a civil lawyer into a family law case is the best idea, by the way. And I've seen it happen, and I've seen it fall really flat. So I encourage people in family law cases to have family law lawyers.
Well, what can you expand on that a little bit? I'm curious to hear what fell flat.
Well, it's a different mindset in civil, and sometimes it can work, but really, if you're a great lawyer, that's fine. But the technical aspect of family law, it matters. And I'm not even one. I don't want to go to Bakersfield to try a case. I like staying in LA because I know there's good lawyers in Bakersfield, which doesn't mean if someone in Bakersfield wants me there, but I'm going to always have local counsel. There's just a body of knowledge you have from doing what you do. And I think that necessarily thinking, oh, because this is the best lawyer in the country, it's going to make a difference in your case. It probably isn't. That's my thought, at least.
Okay. Well, I think that's a perfect note for us to wrap up on, since we're almost exactly out of time. So even though I'm sure we could I've got about 1 million more questions, we could keep going all afternoon. But thank you so much for being with us today. And that wraps up our episode. We hope that everyone will mark their calendars and join us for our next episode on July 7th with Judge Riff and August 4th with Dana Lowy and Doreen Olson. It's all going to be at 12:30 p.m. Registration links are posted on the BHBA calendar. We want to thank Genna and Alex at the bar, the Family Law Executive Committee led by Carrie Holmes and Ron Reitshtein, and of course, all of our section sponsors that we acknowledged in the beginning. And again, most importantly, thank you, Anne, for being here and sharing all of your knowledge and experience that you've gained over the years with us. We hope everyone has a great rest of the week, and we'll see you here next month.
Thank you for having me, and it was wonderful to meet both of you.
Thanks, Anne.
Thank you.
Thanks.